we appeared before Justice Principal Judge Justice Hedwig Ong'undi of a petition by one Charles Rubia, which was challenging the charge sheet pursuant to the decision of Justice Mrima that declared the police charge sheet an illegality. On Monday, after that judgment of Justice Mrima, the DPP unleashed the first charge sheet, which we challenged that charge sheet was not gazetted. The logo in the charge sheet is unknown. The parameters of Section 137 of the CPC and Section 89 and Section 134 of the CPC were not followed. The matter was placed before Justice Mrima, who said that matter be placed before Justice, the Principal Judge today, Justice Ong'undi, and we did appear today. And the proceedings of that matter is that by the time we were appearing today, the DPP has generated more than 8 different charge sheets. One, the charge sheet, the first one that we attacked, the DPP changed and generated a different charge sheet. We attacked that one, it generated another charge sheet. So daily, every day, the DPP generates a new charge sheet. We have raised that question to the judge that has necessitated us to amend our petition severally, because every other time we file a petition, the DPP generates a new charge sheet. 2, we also brought to the attention of the court that the DPP in his own internal communication has disowned that he never sought prayers before Justice Mrima to the effect that he be given the power to make the charge sheet. So the DPP had not filed his response, and because of that they were asking for 14 days to do a response. The learned judge has refused and gave the following directions. That 1, the respondents have now been given 10 days to respond to our amended petition. 2, the petitioners have been given 5 more days to do a response. The learned judge said the matter is of great public interest and she cannot give conservatory orders on the ground that there is an appeal pending in the Court of Appeal, and therefore directions are likely to be issued by the Court of Appeal. But we did impress on the court that the affidavit, one signed by the Inspector General of Police, has provided a situation where completely the criminal justice system has collapsed in the country. Nobody is being charged now. All the thieves, sorry, I have daughters, all my daughters are worried because the defilers cannot be charged now. They are free. The murderers are walking free. There is a complete shutdown. I practice criminal law in Milimani Law Court. To date, nobody is being charged here, which is a replica of the whole country. And the affidavit of the Inspector General in the Court of Appeal is very clear to that issue. Anybody alluding to the fact that the DCI is a junior officer and the IG is a captive of the DCI seems not to have gone to school properly to understand that the infrastructure of developing and the content of a charge sheet are provided for in Section 137 of the Criminal Procedure Code, where the fingerprints must be done, the statement of caution and charge must be done, a charge sheet must be drafted and signed before anybody can arrest that person. So today, the police cannot arrest anybody because they do not know what offense, what charge sheet, what charge is going to be drafted against those people. Logistically, we were telling the court that the implementation of Mrima's judgment is almost humanly impossible, and that is why the DPP has generated more than 8 types of charge sheet within 10 days, which means almost every day there is a new charge sheet that he is generating. That inconsistency is what has led to the stalemate that we are facing. Remember, we did a letter to the president telling the president to compel Noordin Haji to resign, or he can also vacate office. That the president came in yesterday. We expect the president to respond to our petition to that. We have also been instructed, now that Justice Mrima has caused a serious breakdown in the total criminal justice system, we have instructions to file a petition for his removal to the JSC, which we are doing by close of business today, because really that judgment has caused great pain to every Kenyan in this country. So we shall be moving to the JSC for the removal of the judge based on the ground of incompetency and failure to understand the criminal justice system, how it works.
You have said a very serious issue here, a very serious point. I just want to know, you have said that the DPP never made any application for him to be given powers to sign the charge sheet. So are you saying that Mrima made a ruling without any application being filed in court?
According to the circular of the DPP, he never asked for those orders. He was a mere respondent, just like the DPP, just like the DCI, which means the judge must have created his own pleadings, his own cases, and gave his own orders. That is according to the DPP. Two, when you look at that judgment of Justice Mrima, indeed, in one of the paragraphs, he contradicts Noordin Haji, because according to Justice Mrima, he says he looked at the police charge sheet and looked at the DPP's proposed charge sheet, and he found out that the DPP's proposed charge sheet is constitutionally friendly to the Kenyan people. Therefore, it is not true what Noordin Haji is saying, that he never presented the charge sheet unless Justice Mrima created that impression. Today, when we were before Justice Ong'undi, the DPP, one represented by one of the top lawyers there, and in fact there were more than 15 of them, is that this question is res judicata, that question has already been resolved through the judgment of Justice Kuril in Cabernet and Justice Mrima. We did tell the court that yes, if the charge sheet that Justice Kuril approved, if the charge sheet that Justice Mrima approved, then how do we have now 8 charge sheets? Only one was presented. That shows a total confusion, a total incompetence on the part of the DPP. So we are saying, if everybody will be charged by a charge sheet created by Omari, another charge sheet created by Shadrach Wambui, another charge sheet created by Martina Supa, how do we have certainty on what document, which form the courts are going to admit? The judge told us very clearly that she cannot interfere with conservatory orders, because that question is before the Court of Appeal, and we are hoping the Court of Appeal will resolve this matter, and probably we shall also be seeking to request the Chief Justice to transfer Justice Mrima, so that there is sanity in the criminal justice system.
Charge sheets are generated after investigations are done.
Yes.
What charge sheets will DPP draw, and he has not investigated any suspect?
Those are the contradictions we are saying, that the format of the ingredient of creating a charge sheet is statutory provided. The procedures are provided. None of that infrastructure is domiciled in the office of the DPP. The only thing the DPP could have done is to send his officers to police stations, so that as the police are investigating and making the charge sheet, the DPP, the State Council, can silence. We raised also the question, when the DPP signs the charge sheet, he becomes a witness. Can a witness still be the prosecutor? It is a criminal justice nightmare, and that's what we expect the Court of Appeal to bring sanity, so that all Kenyans and anybody in the country is safe.